Court calls the case, People versus Robert Heft.
Good morning, Your Honor. Amy Rise on behalf of the people.
Good morning. I'm the Chief Public Defender appearing with and on behalf of Mr. Heft, who appears by Zoom. Mr. Heft,
Robert,
please
we're here for
state
you.
your name for the record.
Monkey. What monkey?
Mr. Heft, can you state your name for the record, please?
Robert Gregory Heft.
Okay, go ahead. Your Honor, today is the date and time step for the competency review. The last report we received was that Mr. Heft is still incompetent. That would have been dated in August. Does the court have any updated report?
We have a report dated November 12th. Has counsel received that one?
Is that fish monkey? Is that the 10-foot? Is that the 10-foot monkey that want to swim? Incompetent.
We'll be right with
Who
you,
is
Mr.
it?
Heft.
Which one?
Hang on, Mr.
Excuse
Heft.
me.
Hold on, Mr. Heft. Hold on a second.
Do you want to take a minute to review the?
Sure.
Yes. Counsel approach.
Better run through the jungle.
What happened?
It just says private now. I don't know.
Is this an anniversary?
We're back on the record in the Heft matter. Counsel has reviewed the report.
Your Honor, we have had a chance to review the report. That's dated November 12th. It's a finding that my client remains incompetent. We have no further evidence to present to the court. All right.
And we would just ask that the work continue, that he received treatment to become competent. And Mr. Brown and I would follow up after the experience to make sure he is receiving that treatment after all.
That is correct.
Having no additional evidence, the court would find that the defendant remains incompetent to stand trial. I'll set a competency review hearing for
February 20th.
2/20?
Yeah.
February 20th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case People versus Deshaun Glover.
Morning, Your Honor. Staff, attorney points to docs, number 79657. What my client, Mr. Sean Glover.
Morning. Your name? Deshaun Glover. All right. What are we doing today?
Your Honor, I am going to ask for another PCC. I know I didn't fill out this.
He didn't fill out the form.
I didn't fill out
He
the
was just
form.
going to march up here.
And I was told
he was
to.
just going to march up here and just do it. And I'm supposed to just not. He marched up. He came up. He said, I'm not following that rule. I don't care what that judge says. He was saying all that. I could hear it all the way up here saying that. And then.
Your Honor, I would like to address bond.
How much time did you need, counsel?
Your Honor, I would just need a short adjournment, 2 weeks.
Sure,
is fine.
2 weeks, all right. Probable cause conference will be adjourned December 5th, 2024, 9 a.m. Yes, as to bond.
Yeah, Your Honor, as to bond, Your Honor, I spoke with his mom. They have retained counsel. Obviously, you know the requirements. He's not going to be a flight risk, Your Honor. This is my client works with his uncle. I can verify the company. He does landscaping. They're doing snow removal right now. And we're asking for a lower bond, Your Honor. If we can even do house arrest, that's fine for right now for my client.
Response from the people.
It's threefold. One out of Taylor for $400, one out of Clint for $3,000, and one out of Genesee for $500. He has 2 prior convictions for fleeing third, one from 2010, one from 2015, a prior conviction for R&O. Beyond that, the nature of this case is concerning in and of itself. The charging GTA on this actually requested a $500,000 cash security for $150,000. In this particular case, the defendant went to the Comfort Inn to have sex with the victim. The defendant and the victim got into an argument, after which the defendant chased the victim with his car and almost ran her over. Law enforcement arrived on scene and observed the defendant's vehicle and observed the victim exit the vehicle and enter the hotel. On contact with law enforcement, the defendant admitted to chasing the victim in the parking lot, but denied hitting her. When the law enforcement contacted the victim, she was visibly distraught and expressed fear of speaking out against the defendant because of potential retaliation concerns. The victim advised that she previously tried to leave the defendant, but he wrecked his car, and when she tried to get her own apartment, the defendant showed up with a baseball bat and began breaking things. And then after he was breaking things, he said, "Are you still leaving?" The victim also advised that the defendant has, quote unquote, people who will hurt her if she speaks out against the defendant. I mean, at this point, I'm significantly concerned. I want to be lower than we originally asked for. I understand it's high, but I don't think reduction is appropriate.
Your Honor, as an officer of the court, actually, I think the victim, she has called me 2-3 times, and they were in a relationship, dating relationship, Your Honor. So that was his girlfriend, and it still is his girlfriend. So I'm not exactly sure what the nature of the victim and what the sister counsel is referring to, but that is my client's girlfriend. They've been in a relationship for a couple of years, Your Honor, and she has called me as recently as today as to try to advocate for my client.
I think given the statements that she made to law enforcement, it's pretty clear potentially why she would be motivated to do that if she has concerns about retaliation, if she were to participate or do anything other than advocate for the defendant. So I don't think that a release would necessarily be advantageous for anyone.
And Your Honor, if I may, we can ask.
Yeah, go ahead.
I want to put in quotation marks, victim. She was willing to come to court today. I just advised not to, just as a ear of impropriety, but she can appear in court, and obviously she can tell you freely what her intentions and fear of repercussions are in person.
Well, I guess I hear what you're saying, counsel, but I guess it could happen. I'm trying to reconcile count 2 as charged with the statement of the relationship of the parties.
And how long have you been dating?
For nearly 2 years now, sir.
Okay, but I guess what I'm getting at is that charge count 2 is the transportation of a person across state lines to assist in prostitution, and that individual named is Miss Loveday.
Yeah, and we are miffed with that.
Pardon?
That we're confused why that was charged, and for the nature, it has nothing to do with any of the police report had anything to do with prostitution or anything like that. Even the victim herself didn't state that she was there to do that. We were just confused and surprised, Your Honor, by that. And obviously talking with her, that she's mentioned to me several times with her talking with her mom, his mom. She's called me several times. I said this morning, and took his car when the incident happened, drove it back to Flint, Your Honor. So this is not what that police report alleges.
Well, I'm okay. Then I'm going to need some further clarification on that before I do anything regarding bond on this. So at this juncture, I'm going to deny the request for.
And I'll have her in 2 weeks, Your Honor, have her here. Thank you.
Thank you. Let's call the case of the People versus Cynthia Settle.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Settle. Ms. Settle, please state your name for the record. Cynthia Settle. Your Honor, we're requesting an adjournment. Ms. Lonnie and I spoke about restitution. I'd like to have some further conversations about that. And that may lead to a resolution.
Probable cause conference, December 5th, 2024, 9 a.m. bond continued.
Your Honor, I don't mean to request a date. However, I do. Ms. Settle works on Thursdays. her boss is not happy about her taking off Thursdays. She is available on the 19th.
Is
and
it like the
26th.
same unhappiness I have with you requesting a date?
A little bit, I think so.
Okay,
yeah.
all right, go ahead.
She is available on the 19th to the 26th. I know that's farther out, but that works better for her work schedule.
So I don't have to take another day off.
She's trying to pay restitution. She's trying to work. She's trying to do all the things.
She finally had a client show up and she wants to make a big spectacle.
She wants to be here in person, Judge.
So what is is there a policy that you kind of have as time off or?
And I think this is like my third day of this, and I've used them.
Okay, so when does that replenish itself for you?
We're scheduled out because of the holidays, so I'm scheduled out for the next 30 days actually, without my schedule for the next 30 days.
You're scheduled off for the next?
No, my schedule has been made for me for the next 30 days.
Got it.
She knows on the 19th and 26th she'll be on call.
I'll be on call.
So she thinks she'll
On call.
be here.
Got it. So, well, okay, here's what I'm asking.
Yeah.
Because this is really gonna probably resolve itself with restitution. Is that
That's what we're hoping. Yeah.
anticipated or no?
I hope so, Your Honor.
Okay.
I think that I sent some documentation to Ms. Perry today that she hasn't seen before as to the amount of restitution. There's things happening here complicated than a lot of the cases we see like this. So I think we need to have a conversation about it, see if we can come to a resolution, and hopefully we can resolve.
Right, but no matter how it resolves, somewhere there might be restitution that has to be paid.
Absolutely.
Right, okay.
Absolutely.
So let me ask you this, ma'am, because I don't want you to lose your job because then we're gonna have all kinds of problems, right? They make your schedule out 30 days ahead. So if you had a court date, you could tell them and that way your schedule wouldn't be affected.
Yes, instead of
Got it. I got it.
And just for the record, if it's helpful, I'm not opposed to going a little bit further out, like into January, if that's going to be easy.
I was doing this. Why is everybody, I've been doing this for a minute. And that's why I asked the question. I thought you were going to stand up and object to it, actually.
Miss Lundy, never.
Oh, yeah.
Not lately.
Okay, not lately, baby. All right, let's do this, ma'am. If I do January 9th, will that help you?
Yes,
A great deal, because then you can work around.
Yes,
All
sir.
right.
Yes, Your Honor.
January 9th, 2025, 9 a.m. Bond continued.
Thank
And I
you.
did that. Your attorney did nothing. All right, no. Take care, ma'am. Everybody just yelling at me.